Thank you. Good afternoon, everyone. Wonderful to see many familiar faces and some of your names if I don't see you on camera. So it's my pleasure to be with all of you. I will quickly share my screen. Okay, thank you. All right, so today I'll be presenting the highlights of our Department of Justice paper. The title is Making Appropriate Parenting Arrangements in Family Violence Cases, applying the literature to identify promising practices. So, of course, this paper is quite extensive in terms of its length, 75 plus pages, and has many appendices and other information and footnotes. So my hope is I can summarize some of the highlights, and that could be important for our practice. So before I begin, I would just give a broad overview of how this paper came about. This was a project that was funded by Justice Canada. This is the updated version of originally published paper in 2009, which was authored by Peter Jaffe, Nick Bala, and Crooks. And it was my great pleasure to work with the new co-authors, again, Professor Nick Bala, Dr. Peter Jaffe, and Dr. Katrina Scott. This previously published paper in 2009 was cited by a milestone Supreme Court Canada decision, and I would very briefly summarize that later in part of my presentation. This project started in early 2022, and we submitted the final draft paper in February 23, and towards September 2023, this full paper was published. And in this 2023 paper, you will find updates regarding various aspects, such as the family legislation reforms, case law, growing social science research, increased recognition of diversity, and many other aspects which we have seen over the decade as a change in our family justice system. We have tackled a very serious problem of family violence and its impacts on adult victims, as well as focused on children in terms of their physical and psychological well-being in this paper. So before I begin, I just want to share that the opinions that we have expressed in this paper and what I will share today, I'm not speaking for Justice Canada or even my fellow authors who have co-authored. And there is a scope limit to the paper as well as what I'm presenting today. As this paper came about from our work and experiences as authors, it does not adequately address the issues faced by the Indigenous survivors and their children. So it is something that is important that it should get its own information and analysis and impact needed, so that you might find that the scope is limited from that perspective. My hope today is to take some time to present the highlights of Justice paper, and then depending on how much time we have, open for question and answers at the end. And if there are any questions, of course, Marianne would monitor those, but I would take questions at the end. So I hope that works for everybody. The primary audience of Justice paper that we have written is, of course, a variety of justice system professionals, including lawyers, judges, and mediators. And there would be a limited use of this resource for even self-represented litigants, but they need much more than the paper, but it could be a starting point. So what my intention today is to present some of the very broader review of literature and statistics as a context, including the importance of the concept of coercive control, touch base on the legal reforms, and then connect that with the need for risk assessment and screening, and then come up with the differentiated parenting arrangements and some of the visuals that we have created, which you can use in your practice for your analysis purposes. Although the focus for today's presentation is on parenting, We all know that all issues are interconnected, and there are major concerns in negotiations around property, child support, or even other issues when there is a intimate partner violence involved as a context. But again, we want to really put it under the microscope what the issues are around family violence and parenting arrangements. So I want to begin at the outset with a note that family violence cases involve huge access to justice challenges. All across the globe, annually, 1 billion children are victims of violence, one way or the other. And again, globally, it is acknowledged that women and children find it hardest to access justice. Poor people, people with disabilities, people with minority ethnic communities, they are again most vulnerable groups that find it hardest to access justice. And historically, family violence was seen as an incident-based concept. One incident and its impact was analyzed in the point in time people were looking at the issue of family violence. But when we analyze the impact of family violence on children's best interest, we have to go beyond incidents and we have to take the holistic approach. And that would mean we have to be multidisciplinary in our approach as well. So the real challenge in tackling this issue is twofold. First is it's not easy to recognize family violence. And secondly, once it is recognized, timely intervention where abuse of power or violence is involved, and particularly when there is an impact or adverse impact on children is to be assessed, that is a challenge. So this is a twofold challenge we are tackling. If we know that, what are the barriers for change? So there is interesting change that has happened in the legal landscape. We have seen multiple amendments to laws, of course, in family legislation aspect. And even more challenging is to keep up with the evolving social science research. We know better than before that there is impact of trauma that we have to consider, and then its social understanding. But then we don't really know how to bring that into our own practices. And again, there is an impact of the pandemic where we saw the spike in family violence cases. People were reluctant to report that during the pandemic, and now we are seeing that these cases are percolating in the system. And it is also part of what is happening as it is resulting in a backlog of cases in the formal family justice system, both actually family and criminal justice system. And that brings another challenge. There is a pressure to resolve and settle efficiently. And my efficiently is into inverted commas. So with all of that, we have seen another shift on the ground, which is increased uptake for other than litigation processes. We have seen anecdotally more interest in family mediation, arbitration, parenting coordination, med-arbs. And in view of that, my presentation today is aimed at mixed group of professionals, although I'll try to keep my main focus on mediators whenever it's appropriate. So now look at the family violence and its context and gender, and maybe some statistics. So if we review the statistics from Stats Canada, the population survey about the intimate partner violence or family violence, if we look at the last 5 years, and all Canadian adults responding to this population survey, 4.2% of adult women reported at least one assault by current or former intimate partner. And 2.7% men also report at least one assault by current or former intimate partner. But the problem is less than 20% people report abuse to police. So these are just the reported statistics, which is not giving us the full picture. And specifically looking at spousal violence, what we see based on reported cases, that all income, all classes of groups are impacted adversely, but more likely the vulnerable victims were younger, who were in the age group of 25 to 34. If they had lower income, they were more vulnerable. There was a distinction between common law versus married couples and their impact of intimate partner violence, indigeneity, immigration status, people coming from rural communities, people who were either separated or going through high conflict separation, were again more vulnerable to intimate partner violence. So now looking at the impact of family violence, how it is gendered. So looking at, again, various reported statistics, because we definitely have to analyze what we know, intimate partner violence or family violence is a gendered phenomenon. Situational couple violence, which we usually know when parties are separating, that in the situational couple violence, it affects both genders roughly equally. But when we look at the gendered aspect of it, women are much more likely to be the victims of serious violence. And the result is, of course, more fear for their safety and risk of being emotionally abused. And women are much more likely to be affected by coercive control violence, and they suffer long-term effects. So looking at the sexual aspect of gender, women in heterosexual relationships are most at risk, and they live in fear, and serious injury and death is reported in this group of identified heterosexual relationship couples. And family violence is also a significant concern in same-sex and transgender relationships, and men could be victims as well. So there is a differentiated gendered impact, but women are the most impacted in terms of injury or effects after the violence. This is very interesting statistics. If we look at the rate of homicides, if we look at the general population, which is the top portion of the slide, you will see that 81% of victims are male, reported victims, and 19% are female. But if we consider the statistics of intimate partner homicides, which is then gendered data, it almost shows the reverse in numbers. 71% homicides, which are substantial majority, are female victims who lose their lives, and only 29% victims are male. So this statistics confirms one thing, that overwhelming majority of male homicides occur outside of private spheres. But for women and girls, the most dangerous place is unfortunately their home. Very briefly, looking at the Death Review Committee's report, the Domestic Violence Death Review Committee report, there is a science behind risk assessment, and homicides resulting from family violence are both predictable and preventable. DVDRC has developed 41 indicators of risk, and almost in 71% cases that they have examined, 7 or more risk indicators were present. So we can definitely use that knowledge to properly screen and understand some of the key aspects that might be the indicators of risk. For example, actual or pending separation, prior threats to kill, or if the perpetrator is unemployed, if there are attempts to isolate, if obsessive behavior or addiction, excessive alcohol or drugs use, or attempts to choke. These are some of the examples that we know could be heightened risk aspects. Now, looking at one more aspect, which is family violence is intersectional. It is layered. In our DOJ paper, we have used gender-based intersectional framework to analyze family violence. We have to consider this intersecting factor of various intersecting factors, but just as an example, gender, sexuality, economic class, whether they have resources or not, immigration status, race, indigeneity, culture, religion. We can name any aspects that are relevant to your analysis, and it would give you something which we call it as subject location of an individual on that family or society's power ladder. And that's how we can use the intersectional lens to consider the crucial aspect of developing appropriate parenting plan if the family violence context is involved. There are intergenerational impacts of trauma on survivors and their children that we need to factor into creating proper parenting plans. And we need to consider sometimes that individuals' life circumstances across diverse cultures and contexts could vary the right best interest approach for developing parenting plans. Although I'm not going into the details, I just want to bring to our conscious attention that sometimes the issues could be structural, which are beyond the control of an individual. And I want to bring in the statistics about the missing and murdered Indigenous women as an example. I'm not going into the detail, but if we look at the statistics, research shows that Indigenous women are 400% more likely than other Canadians to go missing. And there is an estimate that around 4,000 Indigenous women and girls and 600 Indigenous men and boys have gone missing or have been murdered between 1956 to 2016. So we know that there has been national inquiry into missing and murdered Indigenous women and girls. There has been call for justice. There are recommendations. And we have a lot of work to do from the Truth and Reconciliation Commission's recommendations. But if we look at the intergenerational impact of trauma and how parenting plan has to consider that as a context, we know that this could be applicable in larger aspect in terms of considering cultural and other impacts that we usually do not consider. And again, in understanding the discrimination, I always like to present family violence from the equality framework. Sometimes we can frame violent behavior as practice of inequality. It could be just because someone is seen other vulnerable family member as someone lower than that, their own rank, they can really behave with them in a violent manner. It could be based on gender, age, or other power dynamics. So sometimes we don't directly connect all these aspects into our framing of these issues. And I'm just bringing it to our conscious mind so that we can think about it while we work with clients. And with respect to importance in recognizing the intimate partner violence, again, it's a differentiated phenomenon. The dynamics and effects might vary. It could actually be an integrative behavioral pattern, or it could be a single incident. It could be repetitive, or it could basically be at a point where it happens only at the time of separation. But now we know that if there is a separation that's ongoing and there are different responses required from legal and social service or support, they need to be differentiated. They need to be based on the individual need of the client or the family that we are servicing. And it's most important is we have to look at the effects and likelihood of reoccurrence of a family violence or impact of pattern. So I know that in mediation process, we do not ask for proof of documents or what your client would tell them about their own experiences. We consider that that is the impact, and that's how they see what's happening with them. But as part of process designers, we have to create the safe space for everyone who participates in our process. And we all know that the reporting of abuse has chronically seen as a challenging process. And as mediators, we have seen that how crucial it is for designing the process, but how difficult it is to gather proper information. Usually abuse occurs in a private space, it's not reported. And there is other end of the spectrum where there are concerns about unfounded or exaggerated allegations. And we have to balance both when we are working in a space of mediation or other dispute resolution processes. And it is interesting that in reality, the anecdotal statistic shows that there are more false denials of abuse than false reports or reporting of abuse. So keeping all that in mind, let's just change the gears and think about what's the impact of coercive control? We all have learned a lot about this critical concept, both in law and social science research. Just to refresh our memory, coercive control is, it refers to the pattern of abuse which happens over the period of time. And particularly for mediators, we always look at the power dynamics. So one party maintaining power over the other is what we are concerned in terms of coercive control cases. There could be some simple signs, such as someone explaining to you that there were threats, there was intimidation, there was emotional, financial, physical, or sexual abuse. Those are, in a way, black and white cases. We do better on those now with our training that we have. But the challenge is, in most high-risk cases, the abuse or this control may not be reported. And it could very well be something as a silent phenomena of isolation, or something not easily trackable because it is technology facilitated. Sometimes there could be stalking, but then it is very hard to prove. So those kind of behaviors in terms of coercive control or pattern of abuse, it takes away the self-esteem of victims, and then they feel powerless and feel trapped into the relationship. It means that as practitioners, we have to develop capacity to identify the presence of coercive control or patterns of abuse. And it is very important to note that coercive control can have profound impact on both adult victims and children who are exposed to such behavior. Again, as practitioners, if we want to recognize the control, the power dynamics, or the impact of violence, which even continues after separation, it is important that the clients that we are working receive counseling, receive supports in a timely manner, which are culturally and linguistically appropriate. As mediators, it's important for us to identify coercive control patterns and its impacts on children, because that would feed our designing of process, which can include whether we need to bring voices of the child in some way or the other, whether it is through your own interviewing of children or involving some other professionals who can do that, and all these aspects of bringing voice of a child to mediation table. So when we assess readiness and appropriateness of cases for mediation, some signs that we have seen and have been now confirmed that what could be the coercive controlling behavior is the client tells you that they are afraid of themselves for safety or safety of other family members. We have seen those scenarios many times. But if someone feels unsafe, if there is a violation of no contact order, if someone says that they feel exhausted because the pattern of abuse has really taken control over their lives, if they feel that they are being micromanaged by their ex-partners, if they don't trust their own decision making, these could be the signs of coercive control. And we have to be attuned to these challenges, because this may not necessarily come as something major concern in our screening tools. So the challenge of coercive control is its insidious nature. It is very difficult to identify and even to prove this kind of behavior in court. The difficulty is the pattern of abuse is not easily meeting the standard of abuse that we know, which is black and white, which is we do a better job in recognizing physical abuse. But the repetitions of pattern and the layered nature or multiple overlapping aspects is what complicates the coercive control. It could be the overlapping aspect of emotional, economic, physical, sexual, or even the threats or intimidation, and combination of all of that could mean that it is suffocating the victim. But sometimes, in some incidences, there are physical violence or intimidation, but it may not be reported. And if there are no reports, there is no intervention from third parties. It is challenging, particularly in courts and litigation, to prove that there is a history that really puts things at a point of concern. So there are two key factors that are useful from the case law that's been developing. I'm not going into the cases and case law today because I want to keep it to the overview of the paper. But in establishing or identifying coercive control, these two factors are useful. Number one, we have to establish that there is identifiable pattern of behavior. It could be, as you're seeing on the screen, various overlapping aspects. But then the second prong of that is it's important to show how it is reasonably likely to instill fear or control over the victim. So these two things combined would allow the judge or whichever setting you are working that the pattern of coercive control has really impacted this family in a way that needs to be considered, and particularly now how it could impact the children. So shifting gears and looking at effects of family violence on children who are not direct victims. Why do we need to discuss about family violence and coercive control when it comes to parenting disputes? It is because now we know that the parenting disputes where there is family violence and coercive control involved has ongoing potential to cause trauma or adverse childhood experiences to children. And there are various ways we can look at it from practice perspective. It could be relevant to parenting disputes in many ways. Just few examples are on my slide. It could be important to recognize that abuse does not end with separation. And we all do a good job in asking questions about the history of relationship. But what is happening right now, there could be challenges for the clients to explain and see exactly what's happening and describe that to you. There could be the undermining of non-abusive parent that could continue post-separation. Again, litigation or other dispute resolution processes such as mediation. It could be used for ongoing control. So the self-determination, which is the key aspect of mediation, could be compromised. The integrity of the process could be compromised if there is an undercurrent of playing of coercive control onto your mediation table. There is an overlap between child abuse and family law. Usually when there is both present, children could be exposed to an inappropriate role model. That's a concern as well, because that could perpetuate through the children. If there are new relationships for the abuser, it could potentially be violent to the new partner, which may not come to you because that's not part of the scope of work you're doing. And in extreme cases, the risk could actually result in abduction or homicides. So if there is a child involved in family violence cases, both direct and indirect exposure is recognized as family violence according to the law. And what we know of indirect violence, which is when children are aware that one parent is abusing another parent, another family member, or a pet, if they hear stories about violence, if they're hearing the arguments, if they see the evidence of abuse, we now recognize that such exposure means family violence as well. Research confirms that even pre-verbal children are harmed by exposure to conflict between parents. If we consider the short-term effects on children of this indirect exposure, boys may be aggressive and girls might become submissive. So there is an impact that perpetuates through the children. And again, there is a gendered impact. If we look at long-term effects, they are greater if the child is also a direct victim of abuse. Long-term effects can be health effects as well, which means that the children who are exposed to the ACEs or adverse childhood experiences, it could even shorten the life expectancy of children. So these are all the impacts, these are the risks. And the other type of risk, which is relevant to parenting, is children could be used as pawns for, or could be used for continued control or abuse, even post-separation. There are various ways that can happen. Children can keep the abuser in victim's life for the visits and joint decision-making, all the parenting-related aspects. Parenting time exchanges are often an opportunity for insult, harassment, or intimidation. Stalking or tracking the victim can be justified in the name of keeping an eye on the children. Sometimes the intimidation is that I'll keep children away from you, these kind of threats, or there could be threats to harm the children. Sometimes it could result in strain in mother-child relationship, or withholding of child support can be a form of abuse that is seen. And in cases that report the abuser interfering with routine of parenting practices, such as children's extracurricular activities, their tutoring, attending religious places, or whatever is happening during their parenting time. If we look at the statistics again, approximately 30% victims of crime in Canada, which is reported, are children or youth. So parental separation, we say that is essential in long-term protection of victims and children, particularly when there is family violence and coercive control is involved. But separation can increase the immediate risk of serious harm or death from family violence for adult victims. So importance of intervening in family violence cases requires recognition of that harm and the risk for children particularly. How to protect children who are living in family violence situation is crucial, and it could be a matter of life and death. 30% is a huge number of victims that we have seen in Canada. We know that recently Kiera's law was passed, which requires mandatory judicial training for judges for family and sexual violence aspects. So we are all professionals, and of course, keeping ourselves up to date on these aspects and training ourselves is important as well. We have to note that parental separation can increase immediate risk of harm, not only for adult victims, but for children as well. And it has harmed or reported deaths for children in Ontario. So as I said earlier, if the children are part of the family that's separating, sometimes children are directly homicide victims. But if they survive, but they are exposed to horrific traumatic events, they lose sometimes one or both parents as a result of the altercations, or their lives are disrupted forever. So it's a matter of life and death in many ways. It may not necessarily always be about their safety itself. So now changing the gears and looking at family violence, and very quick refresher of the reforms in legislation. I'm not going in detail, just refreshing our memory and connecting the topic, because I know that we have all learned a lot about the changes in Divorce Act and the Children's Law Reform Act. It's important to recognize that now we have a definition of family violence since March 2021. It's any conduct by one family member towards another, which is violent or threatening. It does not have to be criminal offense, although there is ongoing consideration of criminalization of coercive control in Canada. The debate is happening. It could be the behavior that shows pattern of coercive control, which means that this definition has recognized coercive control as a form of family violence, and there has to be a fear in the mind of the victim for their own safety or for the safety of others in the family, including children and pets. So looking at the specific family violence provisions, and I have gathered this for you, it doesn't have to be something I take you through everything at this point in time, but another aspect of amendments to Divorce Act was the enumerated best interest test. It took two-pronged approach to family violence. One is analyze what constitutes harm, and secondly, what can be done to reduce such harm. And all these provisions that you will see are various aspects that would see the percolation or impact of the having of family violence definition or enumerated best interest test. And just as an example, now you will see that the primary consideration that the court would do in parenting aspects is looking at the children's safety, security, and well-being. That comes from Section 16, Sub 2 of Divorce Act. The best interest criteria is very specifically laid out for family violence cases, and the court would consider the impact of family violence in these arrangements. Supervised parenting time and transfers are specifically addressed in the provisions of Divorce Act and corresponding CLRA as well. There are provisions with respect to prohibition on removing the children from particular geographical area without written consent or any court order. There are exceptions to the change of residence or relocation provisions, which are really important. There are provisions to promote coordination between the intersectional cases where criminal, child protection, and family cases are involved. So these are all provisions which are really important to consider. But I would just like to say that the wider definition of family violence requires us not just to consider the abusive or violent acts, but consider the context. And which means that we have to ask questions with respect to nature, seriousness, frequency of family violence, when it occurred, what are the patterns, what are the controlling behaviors, are the children directly or indirectly exposed to family violence, what are the steps taken by the perpetrator to engage into changing their behavior or improving their ability to care, and at what point in time it meets the need of a child. What are the consideration for a child's cultural heritage as a context. So these are some of the things that we have to consciously think in terms of having the family violence and parenting issues connected. One more major aspect of the amendments through Divorce Act was focusing of best interest of the child, promoting more efficient family justice system. And in view of that, some of the duties were recognized. And of course, there was strong focus on promoting family dispute resolution in appropriate cases. So the new duties, I'm not going into the detail, but the duty for parents is to try to resolve dispute through family dispute resolution, alternative dispute resolution, or I'll call it as FDR, to the extent that it is appropriate. Lawyers or legal advisors have duty to, of course, encourage the clients to consider the alternative dispute resolution processes when it is appropriate. Informing parents about their duties to be good parents, which means that we don't just stop at the point that it is our ethical duty, but now it is laid out as a legal duty, particularly for lawyers who will help their clients see the best interest of child, the need for children to adjust with the changes after separation as part of their role. And for judges, of course, there is a new duty to mandatory finding of family violence. So these are important changes, and I just want to very briefly refer to this case, very simple, easy to remember citation 2022 SEC 22. It is a case, Benedict and Greblionis, and this is a milestone case in 2022. This is, I'm bringing this up because in this Supreme Court decision, the older version of this paper was referenced, which was originally authored by Peter Jaffe, Crooks and Bala. So sometimes it is important that what we are understanding through such literature can be considered, and a judicial notice is taken and references are made by the apex court. So we can look at these kind of materials and bring it into our own practices. So this decision written by Justice Karakatsanis is very interesting to read. You will see the slide is a little wordy, and I apologize for that, but it is really important to consider some of the major takeaways which are crucial in cases where the context of family violence is involved, and particularly the parenting aspects have to be considered. I'm just going to summarize 5 major takeaways from this case. There is a citation and you can read the case yourselves, but it talks about, number 1, judicial finding of family violence to be a critical consideration in the best interest of child analysis. It means that whether we are in litigation setup or whether we are in other alternative processes, the critical consideration has to be given to the impact of family violence when we are analyzing the child's best interest. Secondly, any form of family violence has grave implication for positive development of children, keeping it child-centric and understanding how it impacts the development of children. Thirdly, being a perpetrator of domestic violence is relevant to the parenting ability. Sometimes we don't do a good job in recognizing and connecting these two things, but the court is very clear there is relevance of someone being a perpetrator and their ability to parent. Fourthly, the Supreme Court recognized that there is a harm to children and it can result from either direct or indirect exposure. For example, as I said earlier, observing the incident, experiencing its aftermath, or even hearing about it. And lastly, Justice Karakatsanis, when she referred the older version of this paper, she recognized that domestic violence allegations are, quote, notoriously difficult to prove. And it takes place in behind the closed doors and may lack corroborating evidence. So I know that, again, as mediators, we don't ask for evidence or corroborating evidence, but for other setups such as arbitration, med-arps, and even for mediation to the extent of asking right questions to your clients, this is relevant. One major aspect of this case is important, that when we are looking at parenting arrangements, there is no presumption of shared parenting. There is Amendment to Divorce Act, Section 16, sub 6 has specified that the court shall give effect to the principle that child should have as much time with each spouse, which is consistent with the best interest of the child. So it is not maximum parenting time, but it is whatever is in the best interest of that child. And that's how, going ahead, we have to consider what are the practical considerations of such aspects in navigating family violence cases. Non-disclosure, incremental disclosure, or false allegations or recantations are complicated aspects. I will not go into that right now, but bringing into the conversation our biases. We genuinely don't want our prejudices brought into our work with clients. But sometimes we gather data in our screening, which is dominated unintentionally by our biases. And for that, using some of the screening tools is crucial. In particularly family violence cases, we can use a three-pronged approach for screening. One is prevention, second is early intervention, and third is de-escalation. And using some or other screening tool can actually allow us to overcome our blind spots. I will not go into the detail of help toolkit, but the help approach, which is developed by the Justice Canada, could be helpful in our role as mediators in having initial discussion about family violence with our clients, exploring immediate risks or what are the safety concerns that would feed our process, learning about family violence to help determination of whatever recommendations for the client with referrals, and then promoting safety throughout our process. Now I will come to the last part of my presentation, which is some of the very useful visuals which we have given in this paper. You will find that useful in your practice. We have created this metaphor of highway in actually practically looking at various types of cases that you can use this metaphor in three different things, as you can see. The first one is cases involving normal conflict. There are separations. They don't always involve family violence. They can be termed as normal conflicts and use the main highway. For these cases, the intervention could be education programs, mediation services, collaborative law processes, or co-parenting plans. Now there is off-ramping. You can see these two off-ramps. Second aspect of cases could be the cases which are high conflict, where there is no violence involved. These types of cases are the high conflict cases with no violence. Intervention in these cases could be parenting evaluation. They could involve therapeutic interventions. They could be judicially case managed. These cases are appropriate for arbitration or parallel parenting type of cases. Now, the third category is the cases where there is family violence involved. And these are the cases they require multidirectional or holistic intervention. In these type of cases, we need to have risk assessment and safety planning. There could be a need for restraining and non-removal orders. So the litigation could be the proper forum for these type of cases, at least in initial parts to create the safeguards. Intervention could be needed for perpetrators, and even services for victim and children should be connected with counseling or therapy. So looking at these type of cases, the third type of cases where family violence is involved, we need to have recognition that there could be a major role for specialized supports, specialized parenting evaluators. There could be parenting plans where it could involve supervised parenting arrangements for children. We have to be cognizant that parenting plans have to be not one size to fit all. We have recommended a differentiated assessment and intervention. And in the interest of time, I would say that these involvement and differentiated approach could take into account four major things. Number one, what is the nature of family violence? What is the timing that it was disclosed? What is the availability of resources for creating safety or accountability or healing, whatever we are looking at? And lastly, the intersectional context for both victims and perpetrators. And again, looking at the differentiated response, it would mean that post-separation parenting would have to consider what are the issues that the abusive parent need to address, whether the finding of family violence is critical in understanding the parenting decision of the victim parent, because sometimes the parenting confidence of the victim can be impacted. We have specifically identified that co-parenting cannot take place in the context if there is a continuing fear or trauma from the history of family violence. When there is a history of family violence, children often want to see, and in some cases might even benefit from having a relationship with an abusive parent, provided this can be done safely. And that safety mechanism could be providing proper counseling and other supports around the children and their emotional safety as well, not only physical safety. And some cases, supervised exchanges and supervised parenting time might be essential. So coming at the last slide, and this is the most important visual, I would say, if you don't look at any other part of the paper, this would be the visual that could really help you in looking at appropriate arrangements with the help of this visual. In this paper, the differentiated assessment and intervention strategies discussed. You will see these are the first three columns. Number one is, of course, asking you to look at history of violence. What's the nature, frequency, and severity of the violence? Second is, what is the availability of resources? Are there any services that are accessible? What are the interventions for victims or even perpetrators and children? Is there any systemic barrier, such as language barrier or poverty? The third one is timing of disclosure and the stage of proceeding, whether it's at the interim stage of the proceeding. If the family is still in crisis, the different intervention would be required in such families. Are there any red flags for lethality? Is there a risk for violence to be continued? All of these things are considered as three-stage analysis that you can have. Based on these three factors, you can then evaluate the risk for children and caregivers, and that would inform you from the low to high risk factors, what is the appropriate parenting arrangement? And you can see that it ranges from low to high, ranging from co-parenting. It can, of course, be parallel parenting if that's the best way it can be done. It could very well be the primary residential parent being decided, whether there is requirement of supervision. And sometimes the ultimate cases, the spectrum would come to the other end where there is a high risk, and those cases would involve no parenting time. So this is probably the most important visual from our paper, and easier to analyze various aspects that you would gather together through various questions that you would ask in particularly mediation context. So I know it was long, but I tried to summarize